Welcome back to Legal Matters. We are now joined by attorney John Hansen from the American Law Firm. And before we talk specifics, John, tell us a little bit about the American Law Firm.
Well, first I want to thank you for having us on the program. The American Law Firm is located in Rockford, and we're near the intersection of Mulford and East State. And we represent clients in many different areas of law. We're called a general practice law firm. And that means we represent clients in divorce and bankruptcy, criminal DUI defense, estate planning and probate, personal injury, to name a few. One thing I want to mention is there's a reason why we're called the American Law Firm. It's because we believe in core American values of honest hard work and respect for individuals. And we believe our method of representation plays that out. No matter the client's background, no matter their problems, we give every client the time to really figure out what their solutions should be.
Okay.
And one thing I do want to mention that we offer that's a little bit special is simple flat fees for any legal case we take in, which are very budget friendly for clients. Sometimes clients are in a financial bind, and we'll offer payment plans for them too. And also we offer free consultations to any client in any area of law that we practice.
Free and flexible, those are some of the keys for
Right.
sure. Well, you mentioned one of the areas that you focus on is bankruptcy. Can you tell us some things about bankruptcy in general?
Sure. Bankruptcy is a discharge of various types of debts. Now, for individual clients, the most common types of bankruptcies they're going to be involved in normally are a Chapter 7 and a Chapter 13. And the name chapters actually come out of chapters of bankruptcy code books. Now, Chapter 7 is commonly faced if somebody's facing a lot of credit card debts or medical bill debts, what we call unsecured debt. Whereas Chapter 13 is often faced when they want to pay their debt, but they're behind, like for a foreclosure, for example, and they're behind on their home. Or if they're owing a lot on a car and they want to catch up on that.
Okay, now what's involved in the bankruptcy process from a client's point of view?
Well, first we sit down with the client to really look at their finances. We'll look at their monthly budget, their income. We'll look at each debt and see what the amounts of the debts are, what types of debts they are, and come up with a real world solution for their financial problems, whether it's a bankruptcy or not. Now, if it is a bankruptcy, we will file a petition that gives us a new case. And the petition gets sent out by the court to all the creditors listed in the petition. And that's important because once the creditors receive that petition, it's an automatic freeze from them conducting any collections efforts. That means they can't file lawsuits, they can't even telephone or send letters. And that freeze is called an automatic stay. Now, this is a major decision once we embark upon this, so we always encourage clients to spend the time with us and make sure we understand all the financial ins and outs before we pull the trigger on that. Now, we do want to mention, we do have attorneys standing by right now during this broadcast, standing by the phones to answer any questions viewers may have right now on this area or any area of law that we practice.
And you see that number on the bottom of your screen, so
Correct.
That's very important. And it does seem like Chapter 7 would be the preferred type of bankruptcy to file for most people if it's a full discharge of debt. So when is Chapter 13 a better option than Chapter 7?
That's a common question. A Chapter 13 would be the preferred option if the person who wants to file is making a lot of money, basically, has a high income, because there's certain income limits that the bankruptcy laws provide for Chapter 7 filers. The second scenario somebody would want to file Chapter 13 in is if they have a lot of assets owned free and clear that they might stand to lose if they file a Chapter 7. Now, even though the bankruptcy laws say you can't file a Chapter 7 if you own a lot of property free and clear, the law does provide for exclusions, as it's called, meaning you can keep certain property and still file a Chapter 7 discharge. The exclusions are varied, as are the amounts of money in each exclusion. So we encourage clients to give us a call. We have attorneys standing by right now. We can kind of walk them through the ins and outs of the exclusions if they're thinking about doing a bankruptcy.
Now, are there any type of debts that can't be bankrupted?
Well, generally there are a few. For example, federal and state tax debts cannot be bankrupted, as cannot child support obligations, and in most cases student loans are protected. But there are even exceptions to those rules. For example, you can discharge certain federal tax debts, and in extreme circumstances you can even discharge student loan debt if you meet certain qualifications.
Now, if a married couple is involved, do they have to file together?
No, they don't have to file together. A husband and wife can file jointly in a bankruptcy of either Chapter 7 or 13, or one spouse can file by themselves. We encourage, when we sit down with clients, only one spouse filing if possible. So we'll look at their debts, we'll look at whose name is on the debt, and we'll try to work out where one spouse doesn't have to file to protect their credit rating and help the family out. And one thing I want to mention is creditors can't go after a spouse just because they're married to somebody who's filing a bankruptcy. So we often talk about that with the clients as well.
That's important to know for sure. Now, if a person has filed for bankruptcy before, can they file again? Is this a one-time deal?
No, they can file again, but the bankruptcy laws provide for waiting periods in between the bankruptcies. And of course, if we do a bankruptcy for a client, we hope we never see them again on a bankruptcy and they never have to do that again. But specifically, the waiting periods are 8 years between Chapter 7s, and between a Chapter 13, you have to wait 2 years from the date of the initial filing to the second one in most circumstances.
Okay, and it's important to note that as this segment is being shown, we do have attorneys standing by right now answering legal questions from the American law firm. The callers have the questions and they will provide some free information. That number again is 815-394-1776. You've been seeing it scrolled on the bottom of your screen. Viewers should call that number right now again to get that advice. When we return to Legal Matters, John Hansen will share his knowledge on estate planning. Stay with us. Welcome back. It's Mike Garrigan and attorney John Hansen continuing to talk legal matters that affect many state liners. And John, you mentioned the American law firm handles estate planning work for clients. What does this entail exactly?
Well, in this sense, estate planning entails drafting certain documents for a person, such as a will or a power of attorney, that addresses what that person's wishes are for where their property goes when they pass away, and for also who takes care of them when they're ailing and they're ill at the end of their life. Now, we call these documents at our law firm the advanced care plan documents because we're basically planning in advance for the care of this person.
So what documents should a person have as part of their estate planning or their advanced care plan?
Well, every case is different, and when we meet with a client, we first sit down and talk about what they want as far as where their property is going to go and who should be the decision maker for the doctors, for example, towards the end of their life. And that being said, though, there's some common documents everybody should have, and I'll go through a couple of them real quick. First, of course, there's the will, which says initially who the beneficiaries are going to be, the heirs to the estate. And secondly, it will say who the executor is going to be. And the executor is a person who's in charge of making sure the will is followed through with. And one thing I want to mention about wills are, a lot of people think wills are just for people that have a lot of money or wealthy people. And this couldn't be farther from the truth. For example, if you're a young person, you don't have a lot of property, don't have a lot of money, but you do have a family, you have a child, for example. The will have a provision in it that says, if something happens to me, I want this person to be the parent, the guardian of my child. And that's just one example of a real vital part of a will that can be beneficial to anybody. Secondly, a real common document that we do is called a power of attorney for healthcare decisions. Now, this is for when someone's still alive, and it only kicks in if that person is rendered to be incapacitated by a doctor. For example, if you're in a coma or something like that, you're still alive, you just can't make any decisions, you can't speak. The power of attorney will direct the doctors to go to that one person in the power of attorney document to be the decision maker for the patient.
And it's a good time to remind you right now, you can use that number on the bottom of your screen right now. There are attorneys from the American law firm standing by to answer your questions on estate planning or any other questions you might have. And again, that would be a free consultation. So John, what role do trusts play in the estate planning process?
Sure. A trust is a common part of some people's estate planning documents. And what typically people will have when they have a trust is called a revocable trust, otherwise called an inter vivos trust. Now, the trust is created while they're still alive, and basically the attorneys fund the trust with certain property.
So what are the benefits of having a trust?
Well, the benefits are many, and not every client needs a trust. So when we have a new client come in, we'll meet with them and look at their assets, look at their property, and give them a diagnosis whether they need a trust or not. If they do, there's some common benefits that they can enjoy. First of all, privacy. When we fund a trust, basically we're moving property into it, into the name of the trust. The person still owns it, but it's in the name of the trust now. So if there's creditors or third parties out there trying to find out what a person has in terms of property or wealth, it's harder for them to find that. Second benefit is simplicity. I mentioned previously that if you have a certain amount of property that's worth over $100,000 or you have real estate, the law in Illinois requires when you pass away that there be a probate court case opened. And a probate court is a public case, and there's many court appearances involved, many months, sometimes years involved, and sometimes thousands of dollars of attorney's fees involved. And a trust can solve that problem by saying directly who benefits from the trust when the person passes away. Now, for many people, their only asset is their house. And if that's the case, they may not need a trust, and we could prepare for them what is called a transferable on death instrument, which basically says who inherits the house when they pass away.
Okay, let's talk a little bit more about this transferable death instrument. How does this work?
Well, it's often called a TODI, T-O-D-I for short, and it gets recorded like the deed to the house, and it sets out who inherits the house when the person passes away. Now remember, the law in Illinois says if you have a house and you pass away, there must be a probate court case opened, which can take a lot of time and a lot of money to do. The legislature in Illinois recently passed a law that says we can now do this transferable on death instrument, which avoids probate court altogether.
So is there anything else, John, you want to leave us with tonight?
Well, yeah, I want to thank you again for having us on the program. Our law firm represents clients in many areas of law, and we believe in the core American values of hard work and respect for the individual, regardless of their background and no matter their problem. We offer to clients simple flat fees for many areas of law, which is a lot more budget-friendly than retainers. For clients that are in a financial bind, we offer payment plans, and we always offer free consultations to any person in the public for any area of law.
Okay, we appreciate your time. Thanks a lot,
thanks,
and your
Mike.
insight. Thanks, John. And we should mention again, the American Law Firm has attorneys standing by right now to answer your legal questions. It's the number at the bottom of the screen. We'll be right back.